Good morning, everybody. Thank you very much for joining us today for the OCNI Gowling's webinar. On the agenda today, Ted, if we can have the next slide, is Ted Betts and Ahab Abdelaziz from Gowling webinar, talking about force majeure and keeping contracts alive with Gowling WLG. My name is Joseph Bastien. I'm going to be your technical advisor for today on the call. At the bottom of your screen, you should see a chat feature. In that chat feature, you will be able to send messages to the panelists. The panelists will be able to respond, and they will answer all the questions to the best of their ability today. Thank you, Ahab, for joining us. If you have any questions, you can email us at webinars@OCNI, or you can ask technical questions in the chat feature as well. I'm going to now hand it over to Ron Oberth, President and CEO of OCNI. Ron, your channel is open.
Thank you, Joe, and welcome OCNI colleagues, partners, and stakeholders to another one of our weekly informational webinars. Today, a topic of significant importance given the situation we find ourselves in, force majeure and keeping contracts alive, which of course I'm sure you would all want to do to maintain your financial viability during this crisis. We're very privileged today to have two partners from Canada's top international nuclear law firm, Gowling WLG, who have agreed to speak to us today. It's really my pleasure to introduce the first speaker, Ahab Abdelaziz, who is a partner at Gowling WLG and global director of nuclear power generation at Gowling WLG. Ahab has done nuclear law around the world. He has spoken on a variety of topics, both legal topics and integrated project delivery topics. I'm also proud to say that Ahab is a member of the OCNI Board of Directors and a longtime avid supporter of the Toronto Maple Leafs. So with that, I will turn this over to Ahab.
Well, thank you, Ron. I really don't know what to say. Good morning, everybody, and thank you for joining us. I hope this will be a productive session for you. Let me introduce the distinguished-looking gentleman on your screen in a suit and tie and glasses. That is Ted Betts. I'm proud to have Ted as my partner at Gowling WLG. Ted is the head of our infrastructure and construction sector group. Ted is also a very active member of the nuclear industry sector group and has done numerous transactions, big, medium, and small, in the nuclear industry, ranging from work for major nuclear utilities in Canada to engineering companies, contractors, and members of the supply chain and international vendors. Ted and I collaborated in negotiating the new build nuclear project for Rosatom in Egypt, and we're getting advice today largely from Ted. I am just sprinkling pixie dust in the front end and maybe a little bit during the questions in the back, but Ted is the fountain of knowledge. I will just take a moment to do a little bit of framing. I don't know who's controlling the slides, but it feels like time to move on in the slides. The first thing that falls to me to say is that the presentation today isn't intended to give legal advice to anyone in particular. It is not meant to be relied upon for your particular circumstances because we don't know what they are, and we don't know that the advice will particularly fit your circumstances. So to be quite frank, we're happy to help and inform. We don't want the liability of being taken to give legal advice when we haven't talked to you about your circumstances. Can we move on, Ted? The good-looking guy is the one on the left. I'll talk a little bit about the nuclear industry context for the fallout of the COVID-19 crisis. I mean, what we're looking at, and what Ted is going to spend quite a bit of time talking about, is what happens within a legal construct, within a contract, within the common law. What happens when a party is not able to perform the obligations that it has in a contract because of events beyond its control? And what are the formalities? What steps do you need to go through? What tests do you need to satisfy? Oftentimes, what you're really dealing with in a circumstance like we're in today with the COVID-19 crisis is not a permanent impossibility to perform, but rather it is an inability to perform obligations in a timely way. So to perform the obligations when they are due. In other words, we're dealing with delay. In many circumstances, in many industries, a delay is obviously potentially a serious matter, but not necessarily devastating. In the nuclear industry, delay has been very much a devastating event. And the reasons are many. If we're talking about a nuclear project context, what we're looking at is the most complex risk matrix of just about any organized activity, certainly of any project activity that we undertake in the world. There is nothing more expensive as a single unit than a new build nuclear power plant. There is nothing more complex. Project plan typically involves thousands of tasks, hundreds of players, and you need to coordinate within the delivery team. You need to coordinate performance and schedule, which is extremely complicated because there is a high degree of interdependence and there are a lot of players. And I'm often look at nuclear projects and think of it like attempting to do synchronized swimming with a team of 1,500 swimmers. It's very difficult. When one thing goes wrong, it goes wrong down the line for everybody. And the one thing you need to be able to do to make it work is collaboration. You need to be able to share information, to communicate clearly, to make sure everybody knows how to anticipate what everybody else is doing. We call that information symmetry. You need to coordinate your movements and the timing of your movements, and in effect, that's integrated project delivery. And when you fail to do that in our industry, when instead of sharing information, people withhold information because they're worried about the fight that's coming. When instead of collaborating on solutions, people say, I don't want to own this problem, I want it to be somebody else's problem. What we typically end up with, Ted, can you go back one slide? Is colossal failures. I mean, failures in the nuclear industry don't come lightly flavored. They're bold, they're devastating, and in recent years, we've learned they're enterprise ending. So when we look at Olkiluoto 3, brought Arriva to its knees, VC Summer and Vogel very much brought Westinghouse to its knees, and this was project risk going to enterprise risk. So now that we're looking, you can move forward, Ted. Now that we're looking at a world where not just one player in a project delivery context, big, medium, or small, is delayed because they've had circumstances beyond their control affect them. You know, like a lightning strike, for example, at your plant. But the entire world has had a disruption of normal activities to varying degrees with varying specific causes. My simple message here is, while it's important to be sending out notices to make sure that your contracts remain alive and you don't end up in a position where you've defaulted on your contract or your contracts terminate, getting back to normal in our industry, getting back to productivity, picking up where we left off, isn't going to come simply. It isn't going to come by itself. It isn't going to come automatically. I think the members of the supply chain, the different tiers of contractors, the owners, need to show the qualities we spent some time talking about from OCNI in presentations and task forces last year, which is collaboration. This is absolutely the time to be sharing information, to be talking with one another, making plans about what the road back looks like, what needs to be put in place from all of the players to make sure that the return to productivity is going to be successful, and to identify what you need in terms of supports from organizations like ours, like OCNI, and the government, if that's what it takes. But my message is, this is, even though we're talking notices, even though we're talking contracts, this really is the time where you accept each other's notices, say, I understand why you're doing what you're doing. Now let's roll up our sleeves and plan on saving your project and my contract. With that, I'll turn it over to Ted, and I'll put my microphone on mute, which I know Ron will welcome.
Thank you, Rahab. So thank you, everybody. Good morning or afternoon, as the case may be, and thank you for joining us. I'm going to start talking about force majeure, but I want to emphasize something that Ahab just underscored, which is the theme of this presentation is about saving the contract, saving the project, saving the workflow. It's not about how to win your case, win your claim. And the solution to the success of the project is going to be everybody's success. And what are the practical, collaborative solutions that'll get us there? But it's important to start with an understanding of the legal rights. They do matter, and they do frame the discussion that needs to happen jointly and collaboratively with everybody. So we're going to spend the next few minutes looking at the fundamentals of force majeure and delay claim law. We're going to find it's mostly rooted in the contract that you've drafted and signed. And then if it's not, where do we look and what kind of relief do we have? So force majeure is a common term. It's there's our history here. We've got a COVID-related event, global health emergency, certainly in Canada, declarations of emergency at the provincial, municipal, and federal levels, significant impact on supply chain and production, as well as construction projects themselves. And the importance now of thinking in terms of the exponentiality of the impacts. The longer this lasts, the bigger it gets on an exponential basis, and not just on a linear basis of adding up days, but the impacts are enormous. And so the critical impacts are bigger and need to be contained, looking at all of the remedies and the discussions that need to happen, as well as I said, starting with the contract. So force majeure is a concept in contract. There is no implied or common law right to relief in your contract just because events out of your control have happened. Most contracts will have some kind of force majeure clause, by which we mean a clause that describes events outside of a party's control and provides some sort of relief. If that event has caused your inability to perform your obligations as set out in the contract. It's contract driven, meaning you have to look at the terms of your force majeure contract, the clause in your contract, to really understand what your rights are and what your processes are and what your remedies are. Courts, the clauses will typically say, you know, the parties have agreed on a certain allocation of risk through the whole contract. One part of that allocation of risk is how we're going to deal with events that are completely outside of anybody's control, and only those risks are we going to say we're going to have a special regime that says these risks are shared because they're outside of everybody's control, and they're going to be shared in the specific way that the contract has said they're going to be shared. It's a contractual right, so you have to look at the contractual terms that are expressly put in to your contract. So typically there's going to be three things that we want to look at in terms of a force majeure clause and the event that gives rise to triggering the force majeure clause. The existence of the event, the qualification is, has the event occurred, the unavoidability or the foreseeability of the event, and the actual impact on performance. So let's break those down a little bit. By the existence of the event, we've got a defined term in the contract. We've got a specific provision that will tell us whether certain events are in or out of the clause and the protection given by the clause. We'll look in a few minutes, we'll look specifically at COVID-19 and this pandemic, but just generally, the contract will often have terms like events beyond a party's control, reasonable control, or acts of God. The contract may specifically identify a whole list of types of events that would, wars, conflict, abnormally adverse weather conditions, and so on. But generally they are similar, and they contemplate events outside of your control. And it's important to also look at what's excluded. Often sophisticated contracts will have clear exclusions, and those are just as important in understanding whether you are covered by the clause or not. And this is what courts will look at in understanding what the parties have decided is the commercial bargain and the right risk allocation that they've agreed to ahead of time. Courts will also look at how foreseeable an event was. It's not just a matter of whether there was a condition that's listed there, but how foreseeable was the actual event that we're talking about in terms of the performance under the contract, whether it's a supply of equipment or materials or an actual construction performance and services on site. How foreseeable was it, and what kind of steps did you take as a supplier to avoid the consequences of that event occurring? And so one simple example would be weather. Rain is always an event that will happen in the course of a year. It's not a force majeure event because we know rain is going to come. Where the force majeure event is triggered is when that weather pattern is severe enough or abnormal enough that it's beyond what somebody could reasonably have expected or foreseen. So the standard would be, what would a reasonable, prudent supplier be expected to plan for and take steps to avoid before the occurrence of the event? And finally, the third branch there, what's the final impact? Was the performance actually impossible to perform in accordance with the contract as a result of that event? It will be incumbent on the supplier or whoever's relying on the force majeure clause to draw that causal connection between the specific event and the specific part of the work that you're prevented from performing. It's not enough just to say there was a war or there was a severe storm. You have to show how that storm or how that war or how that pandemic, as we'll get to, has prevented the specific work that you're required to perform in accordance with and under the terms of the contract. In fact, the standard is quite high, and force majeure clauses are actually harder to deploy than one would imagine. The event has to be specific enough, and it has to make the task or the work, the specific part of the work, impossible to perform, and impossible to perform in accordance with the contract. That includes performing it in a timely manner. Can the supply of goods or the services that are impacted by the force majeure event still be performed but in an alternate way? Are there alternative sources of supply of goods? If an employee is not available or workforce is suddenly not available, are there other employees or other staff or personnel or expertise that can be brought in to replace them? In a lot of case law, as we'll see in a minute, and we won't get into the case law, you'll be happy to know, we find that all sorts of things that are actually, would feel outside of one's control, courts have looked at that and said they're not fully outside of your control, so that is your risk. And it's really important to understand that. Workforce, the unavailability of workforce, generally speaking, is not grounds for a force majeure claim. The unavailability or sudden rise in prices that is outside of your control is generally not considered a force majeure claim. Now we'll look at that a bit in the context of this pandemic and see if there's anything different, but that's a general. So the view of the courts would be, there's lots of steel available in the world. There's lots of sources of concrete. There's lots of sources of materials. The fact that risk is on the supplier to provide. And if you can't provide it at the same price, well, that's your risk, not the owner's risk, because you've got a contractual bargain, unless it's a cost plus or time and materials type of clause or supply. Usually there's a fixed price for such things, and that's what the commercial bargain is. The fact that world events have given rise to reduction in availability or increased prices is generally speaking going to be a risk the supplier carries unless the contract says otherwise. And we'll get to some exceptions to that, important exceptions, especially in the pandemic world, but that's the general principle that comes with the force majeure clause. There is lots of case law. We're not going to get into it. You'll be happy to know. Happy to talk about that, or if you want, these are some of the main cases. But what's clear in all of the cases is that every event of delay or claim for force majeure is always going to be fact specific. It's going to be based on the specific terms of your specific contract, the specific event, and the actions that were taken both before and after. And so it's going to be important to track all of that and to document it, especially in establishing any kind of rights or claims to relief that you may have after the fact, and especially in going and sitting down with all parties to the project or to the supply chain when we get to working through solutions, because you want to show exactly what has been done so that we can work out the best plan forward. So COVID-19 and our global pandemic, how is this different? How does this actually work through in a typical force majeure clause? Again, you're going to have to look at your own specific contract. Most force majeure clauses, frankly, do not specifically identify plague or disease or pandemic as a specific identified event. Some do. If it does, then you're clearly in. I would say, and most people would take the view that a pandemic is part of the world of that's covered by the basket clause of events outside of your control. But again, the pandemic has to be looked at very specifically. What is it about the pandemic? What is it about this disease that is actually impacting the work? Is it employees who are sick and can't show up for work? Or is it more likely government orders and conduct that has to follow new rules and laws that governments implement or block on the trade routes that are impacting the actual performance under the contract, the supply. So we do have to draw that causal connection between the specific event and what is the event. The event is actually just as often going to be the government actions or other reactions of other parties to COVID-19 than it is the simple fact of COVID-19. And we're going to have to draw that connection, that causal connection, to the specific parts of the work that are no longer possible to be performed. A lot of work would be in the supply chain as planning and designing, and that may not be impacted one way at all. It may make it more difficult, but making it more difficult isn't going to trigger the force majeure clause in most cases, because we have we have ways to communicate, we have ways to prepare documents, even if it's more difficult and we have to set up technology at homes differently in order to continue on with the work and the preparation for the supply. We're going to have to do that, because that in and of itself is not enough to trigger the force majeure clause. Does it reach the impossible to perform standard that we talked about earlier? Specifically with workforce, this is one area where we have some direct impact from the disease itself. We've got employees who can't come to work because they've been struck down by the disease. We also have, in most cases, government orders, at least in Ontario and most Canadian provinces, that say if you have the disease, you cannot come into the work. You cannot come to the job site to perform. Even if your workplace is an essential workplace and you're allowed to continue operating under our shutdown orders, sick employees are not allowed. And so how does that impact? Well, that's starting to get into the force majeure world. And especially in the nuclear sector, with such high level of expertise, it's not so easy to just simply swap out employees. And so as a result, very quickly you can find that where a normal supply chain lack of workforce or labor supply might not get you into a force majeure clause, in the nuclear space, you're going to have to look at the specifics, but it could very well get you into a force majeure claim on its own. Going forward, we've got a different dilemma, and that dilemma is that we now know about the pandemic. And so we have, if we've given our proper notice, if we've given that we have the delay, potential delay, if we've done the mitigation that we need to do to avoid and minimize the impacts and done all that we are supposed to do under the contract to protect ourselves and the project, going forward though, we now know about COVID-19 and the pandemic and most of the government actions that have been taken already. And so what we call the foreseeability window is closing. The impacts are more knowable, and therefore the reliance on force majeure clauses reduces over time. We do have to continue to take those steps to mitigate. We do have to continue to take the steps to monitor and monitor impacts and monitor the actions of governments, not just in our locality, but across the world, because the nuclear supply chain is global. But barring any new events, over time, the impacts and the relief that's offered from force majeure clauses reduces, because there's nothing nothing unknown now about it in terms of the impact, the occurrence of the event. And so we want to be careful and aware of that. So just to touch on the relief that's offered in a typical force majeure clause, obviously you've got a performance obligation under your contract, and the first and most important thing to be aware of the force majeure clause, if you've claimed it and you're eligible for it, is that it relieves you from the performance. So you're not in default for failing to perform the specific parts of the work that you are prevented from performing because of the event. It does mean, and you have to be aware, that other performance obligations of the contract that are not prevented by the event of force majeure still must be performed to the extent that you can. Secondly, typically a force majeure clause will provide time relief, schedule relief for the performance of the obligation. So you're not just lifting the performance, but you will get some relief at the end of this. Once the event has disappeared, you're not back to the same schedule. You will be entitled, generally speaking, to some relief. Again, you're going to have to look at your specific contract to know what that looks like, but and whether it's just limited specifically to the time of the event. I would argue in a nuclear case, and especially supply chain, it's much more complicated than that, as they have pointed out. You're going to have to consider the design consequences, the regulatory consequences, the impact on other people and other people in the supply chain to really understand what's the true extent of the delay that should be added to the schedule. But you will, generally speaking, be entitled to some level of schedule relief, and that impacts any liquidated damages that are in the contract typically. There are also other provisions in the contract that you're going to want to look at. We're going to look at those in a minute. But one important aspect, and often the largest part of the difficulty and dispute over force majeure claims is, what are the costs? Who carries the risk of costs? So when it comes, I said at the outset, force majeure events are considered shared risks because they're outside of everybody's control, so we're going to have a special regime for these. Schedule risks, we're going to relieve, and performance risk, we're going to relieve the contractor from that risk. They're not going to carry that. The cost risk is something else though, and that is going to be specifically driven by the contract. A lot of contracts will provide for explicitly the relief on the schedule and performance, but not cost relief for the extra time of delay. Again, it will come down to the contract. There's no automatic right to the costs that are consequential to the delay. So you're going to have to look at your contract specifically. There is also, in many contracts, an ultimate time duration suspension and termination trigger. If performance is not capable of continuing on for a certain period of time as set out in the contract, it may trigger other rights of suspension or termination, or a right to redo parts of the contract for the owner or for the contractor. So again, you're going to have to look at the specific terms and the regime that's set out in the contract. These are not things that get read out or implied by a court. One of the key additional terms to bear in mind, and we highlighted this at the beginning, but we're going to highlight it more here. The jurisdiction will matter. So we're talking about Canadian common law, and Quebec's a little bit different with their civil code, but not too different. But this presentation is about Canadian common law. You will have to look at your contract and figure out what jurisdiction governs your particular contract, because the local law will matter in how force majeure and frustration and performance is governed. So we'll spend a couple minutes just talking about other terms of the contract. Force majeure is the most obvious term that everybody turns to in events like pandemics that are impacting and disruptive across the board. But there are all sorts of other terms of the contract, especially on larger, complicated contracts, that may bear looking at. Sometimes you've got a force majeure clause. Sometimes you also have other delay clauses and excusable conditions and unforeseen conditions clauses that may bear on the particular circumstance of COVID-19. Government order clauses. We also have specific clauses that will set out if government issues orders, changes the laws, directs you to take certain actions, that gives you specific relief, stop work orders or anything like that. That will give you certain remedies on its own. Those may be separate contractual provisions. Typically, you have an obligation in your contract to comply with laws. And so even if you don't have a specific government action clause, you need to consider what the new world is with all of the government action that's been taken to date, and your obligation to comply with that, not just stop work orders, but what is the new regime for how you carry out the work? If there's health and safety protocols that the government has implemented and imposed on all performance of all contract and all work, then you need to follow that. And how does that impact the whole project? The contracting party that you have, your counterparty, may in fact be the government, often is in the nuclear sector. So their actions in and of themselves may be a trigger for government action that you need to consider. The default clauses themselves, even if you don't fit squarely within a force majeure clause, is it a default in and of itself because you're delayed? You'll have to look at your own contract to make that determination. Often there are thresholds and other specific default provisions, and that has to be followed. You fit within the default or you're not a default at all in the contract. And finally, as I mentioned earlier, if there's a long-term duration to COVID-19 or the impacts and stop work orders and government actions or shutting down of trade routes and customs are long enough, there may be automatic suspension and termination rights, or the right of a party to do so, either the contractor or the owner, to say, look, this changes everything in the contract to such an extent that we need to start over in terms of what are the terms of the contract, the pricing, the time for delivery, the performance, and so on. So you do need to look at the whole contract beyond just the obvious of the force majeure and delay clauses. So we've looked at the contract, and that's obviously important because it will often, in clever contracts, especially sophisticated contracts in the nuclear space, will have thought through the these kind of issues because they're important to deal with and allocate and to price out beforehand. But what if you don't have a force majeure clause? What if you're just on a purchase order where you've got a robust contract that just simply did not have a force majeure or a delay provision that addresses this situation? There is general law that does apply. It's called the law of frustration. It's a higher bar, higher threshold. It's very difficult to actually rely on this, and it does have different consequences. The nice thing about a force majeure clause is it will say not only are you allowed some relief, but your relief is only to the extent of the event that we're talking about, and it doesn't end the contract. The contract still continues. We're still going to work towards and work together to finding resolution past this event so the project is a success. Doctrine of frustration is where you are frustrated in performing the balance of the contract. So it's a fairly high bar. Sorry, not a fairly high bar. It is a very high bar. The totality of the contract needs to be frustrated, impossible to perform the substantial portion of the contract. So the contractual bargain that people have made is really rendered impossible to perform. And as a result, the consequences of that, of finding, and the relief that's available are equally broad. It is, if the full benefit of the contract has been frustrated, then we're going to wind up the contract and the obligations altogether. So it's not a remedy you want to seek lightly, but it's really as a last resort when you don't have a contractual remedy that's been set out in the contract for force majeure. So that, in very brief, is the law of frustration and the law of force majeure as it relates in our nuclear supply chain contracts. Obviously, as I keep coming back to, the first point of force majeure is to understand that it's driven by the contract. And as we started out at the beginning of this whole session with Ahab's comments, the success of the project is going to be beyond just enforcement of the contractual terms. What is success, in fact, in this kind of a case in nuclear space, and even when you're trying to rely on the specifics of a force majeure clause, are going to be driven by the conduct and the prudent conduct and practical conduct of the parties. So both in terms of your legal enforcement of your rights under a force majeure clause, but also more generally for the success of the project itself, it's going to be important to be proactive and really think through the specific causes, the specific events that are giving, and the specific impacts. What specific work is delayed, made more difficult, or made impossible, and how can we work around that? What are the solutions? You've got a contractual obligation to mitigate, but also the success of the project means you're going to come back to the other parties involved. If you're an owner, you're going to talk to your contractor. If you're a supply chain supplier, you're going to talk to the contractor or the owner that's hired you, and you're going to work out the best solutions because you can't do it on your own. And there are so many other parties, as they have mentioned. You need to work collectively. One party's immediate, obvious solution may be the least ideal solution when we look at everything. So the success means being proactive, but proactive with everybody, responding promptly and getting on with it. Collaboration is key, but that cuts both ways. It's you know, we're not just talking about, it's not just a one-way street. The supplier isn't the only one who needs to be flexible here, but you can help owners in finding ways to minimize their concerns and risks by encouraging them to be flexible and finding ways that they can be flexible while still reaching the ultimate goal of the project success. Jointly developing creative solutions. You know, it may not be possible to avoid all of the impacts of this COVID-19, but what is the best way to minimize those? And one of the best ways is going to be dealing openly, transparently, and comprehensively with your analysis, and dealing with each other without fear of reprisal or being noted in default. And bearing in mind at all times throughout the regulatory requirements in the environment that we're working in, because as creative as we would like to be, as commercially sensitive as we might want to be, there is still a regulatory reality that we have to comply with safety as the ultimate priority. So a lot of the advice we're finding that works successfully is the proactive planning. We know COVID was coming. We know there's a pandemic here now. We know there's a chance that there might be a resurgence in the fall. There's a lot, at least in Canada and North America, in the northern countries, that these kinds of pandemics often go away and then they come back again. So what kind of planning can we do now? What Rescheduling or resequencing can we do to reorganize our work methodology? So on the site, we are socially distancing. We've got time factored into our day so that we are screening at the gate and doing all the kinds of things that we need to do to be healthy and safe at the workplace and comply with government orders and continue on with the project. How are we going to recover costs? What's the best way? We might not be able to install or pour all the concrete that's coming onto site, but maybe we can stockpile some. Maybe we can pre-order some now and stockpile it so it's ready, and whenever the event, the COVID-19 allows us to proceed with the next step in the project or in the supply, we're ready to go. Maybe we talk to owners about, look, let's just work through this without the threat and worry of these delay claims, so that we're not in fight mode, but collaboration and workout mode, solution mode. Let's just do away with the damages threat, the liquidated damages threat, at least for now, or at least for a certain block. Talk about grace periods right off the bat, so nobody's worried about that. Maybe the owner could even offer some incentives to start working overtime when we come out of this, or right now, to the extent we're allowed to continue. And talk about reallocating or sharing of all the new risks that might come. Let's anticipate some of those that might come, and rising prices that might come as a result of the recession that we may already be in. So the key there is collaboration and working through that, but eventually we will come out of this, I'm confident. And it will come down to looking back and assessing what happened. What was the cost? What was the time delay? What's right in getting back on track? That all of this can be loosely described as the quantification of the force majeure. And it's a complicated area. It's not going to be easy, and we're not going to get into the detail here. You got a long way to go. There's a lot of factors, especially in the nuclear space, that are going to impact that. Design considerations, regulatory, plant shutdown windows, that time when work has to be done, and we've scheduled a shutdown and we've missed that window. Now what happens, and how? So the exponential consequences in the nuclear space of the impacts of COVID-19. And so there's the point of this slide, and this part of it is just to identify this is complicated, and it's going to be more complicated if we're not doing our job right now to carefully and closely monitor and document. Log the delay claims, log the impacts specifically. What are the productivity impacts beyond just the schedule and the cost? Did we have to do work differently because of certain government orders to work in a safe way, as we mentioned before? Let's document that, keep track of it, and then we've got something we can talk about and look at specifically in order to find the best solution forward. That's the gist of our presentation. We have carefully allocated some time to address questions. That is a bit of a flyby. We recognize that. Most of these projects will have some force majeure impact without a doubt. It will come down to the contract terms. We've tried to lay out the broad parameters and some of the specific requirements that we would typically see in a force majeure clause and in these contracts, and the best path forward for success of the project, because the success, any kind of dispute is always going to be a failure, not just of the project, for both parties. By the time you get resolution, the costs, not that we don't love the legal fees that we earn on these kinds of disputes, but we want to avoid that as best we can for the success of the project. And that means collaboration and work and starting from understanding what your rights are under the contract. So with that, Joe, I think we will open it up to any questions. I think the process is, well, Joe, maybe you can explain the process on the how we're going to deal with questions, and then we can start addressing them.
Perfect.
Yeah, and
Thank you
Ted,
very
I'm
much,
just
Ted.
gonna Ted, I'm just gonna jump in for a second. And Joe, I don't know how you can work this, but I would be very interested to get feedback from participants on whether they are currently, their organizations are currently engaged in any kind of extraordinary, beyond the usual case planning and communication with customers to, basically looking forward to the day when activities can begin to resume, how that will be done, what to expect, what problems they might anticipate. Is there any kind of joint planning happening between your organization, others that are involved in delivering alongside of you, and your customers? Or is that all waiting largely to see what happens when the crisis is over? Don't know how we get that feedback, Joe, but that's your job.
Okay, so we're not set up for polling on this webinar right now, but if people want to type into the chat a simple yes, I am engaged in contract renegotiations, or no, I am not, we can collect and collate that data when we export the chat logs. And if companies want to provide any additional detailed information, you can put that into the chat feature directed at all panelists, and we will collect and collate that for you, Ahab.
Thank you.
Joe, thanks for unmuting me. First of all, Ted and Ahab, that was a wonderful presentation, very clearly spelled out, clearly articulated. It really underscores, in my view, what you've been preaching for a good while, Ahab, about the value of integrated project delivery, collaboration, transparency, and it's in my view, essential at a time of crisis, that people bring that sense of goodwill and transparency and collaborative problem solving. I can answer to some degree one of your comments because I am in regular discussions with supply chains at OPG and Bruce Power, in discussions with some suppliers who are seeking support. But what I found, there's been a high degree of collaboration between the procurement teams and the life extension teams at Bruce Power and OPG and their suppliers. It's in everybody's mutual interest to ensure that the supply chain is intact, and both utilities are doing all they can to ensure that. You know, one specific example is that with the announced slowdown or delay of Darlington Unit 3 refurbishment, companies that were manufacturing components, long lead components, have been encouraged to continue to do so. But because OPG can no longer take delivery of some of those manufactured components, OPG has been telling their suppliers in a very collaborative partnership fashion, once you've completed the fabrication of the components and we've inspected them, we will pay the invoice upon inspection as opposed to upon delivery. So they're asking suppliers to, if you can, please store these components at your facility because we can't accept them at site. We won't deny the payment of the invoice. And in fact, they've even gone so far as to say, if you incur additional storage costs, we will cover them for you. So I've seen a huge amount of goodwill between our utility partners and our suppliers in a very collaborative fashion. So even though theoretically these aren't necessarily integrated project delivery contracts that they're working under, I see people actually acting as if they are, and everybody wants to come up with a mutually beneficial solution.
Thank you, Ron. And I see an answer from Michael Dubreuil, if I'm saying it right. All customer Engagements have changed because of COVID-19. Work progresses remotely where possible. On-site work continues under lockdown, lock-in situations. Force majeure clauses have been triggered. Extreme collaboration is occurring to ensure return to normalcy when it does occur. Projects are being pushed out, some by as much as a year. That's extreme collaboration is a phrase I'm going to carry with me.
Yes. I don't see any copyright on that, so we're good.
While we're waiting for more questions, I've got one of you, Ted, from your presentation.
Sure.
It appears then that force majeure will be more accepting of schedule delays, but the increased costs that a supplier may incur while the supplier adjusts his workforce or brings in alternative supplies or alternative labor tends to be less easily recognized as a reasonable cost under the contract or a reasonable modification of the contract. Is that generally correct?
That it's again, it's going to come down to the specifics of the contract, and often cost is dealt with separately, even excluded if it's addressed. For smaller contracts, people might be familiar with template standard form documents often used in the industry in Canada, the CCDC type documents. Mm-hmm. Break it out quite explicitly. If it's an owner fault that's caused a delay or an owner decision, then you get schedule relief, performance relief, and costs and profit. If it's government action, a stop work order of some sort, you'll get performance relief, schedule relief, and reasonable cost directly associated with the delay. If it's a force majeure clause in a typical CCDC contract, you get performance relief for the duration of the event. You'll get schedule relief for a reasonable duration, but not costs. And so it becomes, and that's just your CCDC contract. Most supply of materials or sophisticated construction or engineering contracts wouldn't rely on a CCDC. So I'm just giving that by way of example. You really do have to look at the contract, and it's often treated as boilerplate, frankly, and it shouldn't be, because you'll have clear exclusions in the more sophisticated contracts that will say exactly what happens with costs and what kinds of processes you have to go through to establish those costs, whether they're directly related or whether your schedule remediation plan that you also have to come up with can automatically give you the cost. It might not just be an exclusion, it might be a permission. In order to get back on schedule, we need you to work overtime. If that's what the contract requires, then you're going to get that cost. It may limit it to just direct third-party costs that you incur as a result of the delay, but not your overhead. It's probably not going to ever cover something like laying off your employees while you have a long-term event that's preventing you from work. But does it cost the physical demobilization and remobilization of the project site itself? If you had to vacate the site of the work, it may. Yet again, it's going to come. There's no automatic on that, and the contracts that generate the most legal work are the ones that are vague and don't address it clearly and specifically, and just say you're freed up from the performance of. It gives you the permission to say you're freed up from the performance, but it doesn't do the back end. It doesn't tell you what happens as a consequence. How do we figure out what are the contractual relief and recovery plans as a result? We all acknowledge this relief, but what does it actually look like? And the contracts that are the most difficult, the ones that give Ahab the most fun and busyness, are the ones that haven't fully addressed that. So you do, again, have to look at the specifics of the contract.
And those are probably contracts that weren't drafted by Gowling WLG in the first place.
You'll also have to, another part, just a simple part of the contract is what kind of a contract it is to begin with. Is it a fixed price contract with a fixed schedule, or is it a cost plus time and materials contract where any delays might be relieved. If it's cost plus, then the price has always been the owner's risk, and so you will be able to pass it along. You don't need a force majeure provision to get those extra costs. Those are extra costs you might already be entitled to in a cost plus time and material type contract. So you really do have to understand your contract, and not just get your lawyers to draft it, sign it, and then put it on a shelf. This is the time to bring it out, dust it off, and have a look at what your rights are.
I've got another question or comment rather than while we're waiting for others, and for both of you. I know that you're not giving legal advice, but do you think it would be prudent for suppliers and utilities now, and customers, to jointly start anticipating, even though there's no real evidence of a fall rebound of COVID in terms of their material supply and their labor? I mean, you mentioned you've got to take proactive action, and there are some who are speculating, and I don't know how prevalent this is, that there could be a fall rebound. I'm not one of those. That horrifies me to think that way, and I won't allow myself to, but it may be prudent. So that planning and consideration costs money. Do you think it would be prudent for suppliers to begin to think that way based upon pretty speculative opinion?
I'm not sure how speculative that is, Ron. I mean, if you listen carefully to the messages we get, I want to say, that are non-political, so from public health officials, the messaging is uniform. It is that we are experiencing, at least in North America, in many areas, this leveling out of the curve, looking forward to it coming down. There is concern about rebound that's expressed, and there is a statement that doesn't seem speculative, that we will be at risk of recurrences until there is a vaccine, and that you're looking at a 12 to 18 month timeline by the time you've got something rolled out. So it would seem to me that in these circumstances, if you're taking on additional contractual obligations, certainly one of the things you've got to think about, because it's more foreseeable, is the prospect that there may be a pandemic, COVID-19 recurrence, and that it may have some impact of a significant level or not in the coming months. Similarly, if you're planning mitigation under an existing contract, I think you have to take that possibility into account. I don't see how you can ignore it. Ted, having set you up that way, I'll give you a chance to disagree.
No, I'm not going to disagree. I'm going to say, proactive is obviously the what you need to do. You need to be anticipating that. You need to talk to all the parties on the project and the supply chain that you're relying on below you, and that you're providing to above you, to make sure that everybody's factored it in. Because once you sign that contract, it is a binding document. And if you're signing a brand new contract now with a specific schedule and a specific price, and you don't address it one way or the other, you're relying on the generalness of your force majeure clause. And it's good. Foreseeability is inherently a very difficult legal concept to describe and in definitive terms. It's going to come down to, well, how foreseeable was it when you signed the contract on April 22nd, tomorrow, that there was going to be this delay that you're now claiming in September because it came back and government opened up the doors to businesses, and then now they're shutting them back down. How foreseeable was that in your planning process? And so why not have that conversation now and just address it and say, look, we know this might come back. We're planning this schedule now, but reserving our right to have another conversation later on. We had one, I was on one project. It's a commercial project in the city of Toronto, multi-use facility, and they've got a big pit right now, and so they're digging that out. But they're continuing on. The general contractor is continuing on to sign up contracts as they should. And one of them came back and said, look, I need to put in all these waivers and releases for COVID-19. And we said, wait a second, you're not even on the job site until November. So, let's look at that then. But we're not going to give you a carte blanche. We're not going to say you get whatever relief you want. We will factor that in. We'll put in a provision that says, look, if anything new develops, then yeah, we recognize that might not have been foreseeable. But we're going to sign a schedule right now that with the information we have right now, that we're building a good contract, a good price, a good schedule, good work procedures that are going to be sustainable for the success of the project in the event other circumvening events that we can anticipate are there. That's just good prudent planning. You do that in any event with weather. So we now that know this is possibly like adverse weather. We know there's a possibility it might come back. Let's build in some float in the schedule if we need to, or some specific provisions. We didn't have a schedule remediation plan requirement in the contract before. Let's put that in now, because we know if it comes back, it's not just about holding your hands up, shrugging and saying I can't work. It's about working towards the true success of the project through that next event.
So what I'm hearing you say basically is that given the fact that we're in a slowdown period now, this would be a prudent time to sort of, and I think a lot of the contracts on MCR and Darlington have been signed. This may be an opportunity to have both parties look at them and anticipate and maybe make some modifications in anticipation of what might be a second wave of impact in the fall.
Yeah,
that would be
a question that's related. I just want to put it on the table, Ted, and then carry on with the discussion. So question, due to the uncertainty without the availability of a vaccine and in view of potential future waves of COVID-19, how do we manage the challenge of rescheduling of activities in the contract? Now I've got to run. I want to take at that, but I'll let you get rolling, Ted, if you want.
Well, it is a challenge. I mean, there's no question. We've got unfolding events. Just specifically on the force majeure clause, there is typically an obligation to give notice, but if it's a continuing, ongoing event, give notice only once. You don't need to give you a continuing notice about the event, unless there's new events or offshoots of that would be prudent to give notice about. And the only thing you really can do is stay on top of it and keep a schedule that's flexible enough or updated constantly enough that you're projecting out the way you would normally at the outset of a project with your schedule, and to document. So track all of these, because as you're evolving with the evolution and escalation of government actions to COVID-19, you have to be nimble and be able to respond to that.
So I want to just add a little bit to that, and I want to go back to what Ron said in the early introductory remarks. What Ron said there is that in a time of crisis, this business of integrated project delivery as a model becomes all the more important. And I think that's a very important observation for this reason. When we've been lecturing on or using collaborative contracting models in the UK or integrated project delivery models in Canada and the US, what we've been looking at are these major, highly complex infrastructure projects, and we've always said these, or the data says, these are the projects that benefit immensely from collaborative contracting. And there's a really good reason, and it actually has to do with your question, Wilson. And the really good reason it benefits is that in these massively complex projects, you cannot predict what will go wrong, but you know something will. you're not going to start a major nuclear project with 30, 40, 50, 200, 250 members of the supply chain coordinating with complex technology, complex regulatory requirements, and have everything go without an unanticipated event, and indeed an unanticipated event that can really damage the project in terms of schedule or cost or even viability. And so the difference between a traditional model where we all kind of line things up in a linear way and say, if, then else. If this happens, then this will be the result and this will be the consequence. And a collaborative contracting or integrated project delivery approach, the quintessential difference is the latter collaborative approach says, we're going to have a method for dealing with crisis. We know something is going to go wrong. We know we can't make a list of thousands of things that could go wrong and agree in advance how we're going to respond. But we're going to build resilience into our system by having a joint project management committee that's going to have different levels of the owner, the contractor, all the people that need to coordinate. When an issue arises, we're going to share the information and we will devise solutions real time together with a view to saving schedule, saving cost, saving the project. We absolutely have to take a page out of that. And so I think your question is actually absolutely bang on. You don't know. It's like, welcome to how you've always been living in the nuclear space. You don't know when you're going to be able to perform again. You don't know when others on whom you depend for your work, whether they're delivering to you or they're part of your delivery, or you need them in a sequence to do their work first. You don't know when and if they'll be able to proceed. And you don't even know that the project will remain viable in the near term. But what you can do is create a project management forum and committee with all of the people that need to be talking and have them talking online like we are right now in some sort of video conferencing, regular meeting with information sharing, saying this is what's going on my side. What you can do is begin to build notional milestone-driven schedules together where you don't know when the start date is going to be, but you're sharing information about how long it's going to take the different parties that are essential to performance to perform these important steps, where you can identify additional challenges and tasks that weren't part of the original performance, that now you need to perform to get things back on track in terms of production or service delivery or project, and figure out how, collectively, what's the best way to address these issues, and then also build in contingency saying, look, this can all go sideways on us again. How will we behave when it goes if and when it goes sideways again? So I think in these times of uncertainty, the greatest resiliency you can develop in the system is through putting in place project management methodologies that allow you to work together, share information, anticipate that there will be crises, identify potential obstacles on your road back to normalcy, and prepare for how collectively you will deal with those. And in some ways, it may never be going back and doing what you were doing before. You may have to be singing a new song or learning a new dance to get to where you were or somewhere analogous to it. So I see that we've got other incoming from several participants. I'll let you carry that, Ron.
Well, there's one here from Sanisha, who's starting a new company, expressing some skepticism about IPD. And Sanisha is saying that the utilities won't accept it because they like to have someone whose neck they can wring if things don't go well. Well, you know, we had a couple of IPD workshops last year that Ahab helped coordinate because he's head of our IPD task force. one with OPG and one with CNL at their big room in Canada. And both those organizations are implementing IPD on projects. The one at Chalk River is probably furthest ahead, and they're using it for the Advanced Nuclear Materials Research Project. They're still in the planning stage, but the parties have come together and they work collaboratively in the big room in Canada. OPG has been deploying the IPD model at its Otto Holden project and intends to slowly begin to expand it into nuclear. So I think we're beginning to see the recognition in the nuclear sector that there is a better way of doing business that AHAB has been telling us about for a good while, and it was successfully implemented in the London Olympic Games, which I think we all hold out as a huge success. Michael Shitlani, I knew Michael would come through with a question.
Yeah, Michael, the question Michael is asking is whether this notion about talking about how we will behave is meant to be a discussion between the parties, you know, it happens anyways, or am I suggesting a new contract language? What you can do it through new contract language. It's done in the collaborative contracting world, but you know, to Sinisa's point, it doesn't have to be. This is about communication at a project management and a business level saying, we got to work together if we're going to minimize the impact and improve the feasibility. And so even if, you know, as a matter of ordinary business, you're not a huge fan of integrated project delivery. I mean, CNL definitely is, but if you're not a big fan of integrated project delivery or collaborative contracting, this is the time to think about suspending that belief and adopting some practices to get the sector, the industry, and projects and delivery back online in the most effective way possible. It could involve some contract language. It could involve some contract language that describes the route back from force majeure as part of the mitigation, or could be done on a less legal level that involves more project managers and engineers and less lawyers. Sorry, Ted, go ahead.
Yeah, I was just touching on that point. Even if it's not across the board, the whole contract, you can still take some collaboration and collaborative approach on specific aspects of the work itself. So, for example, if we're heading into the summer and we're worried about our supply chain below us, our material suppliers and their financial health, for example, maybe we can. We know we're going to source some of the materials from some subs and suppliers that might be at risk, and yet the owner, the utility, their design plans aren't fully baked yet. So we don't know. We don't want to take the risk of making any pre-orders because the owner hasn't decided which way to go on a certain order. Well, let's talk about that. Maybe the owner can share some of that risk. Maybe we think we're pretty sure we're going to go down this route if we press them. Let's get them to agree that we can place some orders down the supply chain and that they will back that up, and we'll just use that to stockpile somewhere. Or they allow us to stockpile more materials, pre-order more materials, stockpile it in the event of the pandemic coming back, so that we've got located on site and they're willing to pay for the storage of, or some other creative solutions to the way we would normally do business on one part of the contract, not necessarily the whole contract, because we've got a contract in place or the utility isn't interested in joining with us on a full IPD kind of model. But we can still work together in specific ways, and that's why sometimes the onus is on the supply chain to come up with the creative solutions and the flexibility to show the owner, really, it's not changing the pricing of the whole project for you or the risks, but you are helping us, deliver the project to success by helping us with the risks that we're dealing with.
And Ted and AHAB, we've learned a lot through COVID-19 about how to communicate differently with one another, how to work remotely. This may be and should be an opportunity for us to learn new ways of managing projects collaboratively, because it's more essential now than ever. So I'm encouraged that we will see a new world at the end of COVID-19, and maybe we'll see a stronger incentive to go towards contracting models that encourage this form of collaboration and problem solving during a crisis. I think we're just, Michael Shitlani's final comment was thank you. Sunesh's final comment was great guys, good work. Let me echo that. This has been a fabulous session. And Ahab, it makes me think that we should maybe resume and have another integrated project delivery webinar down the road as a follow-up to this one.
Let's do that.
Well, thank you, both of you, for giving us an hour and 15 minutes of your valuable time and sharing your insights with us. And questions are still coming in, but I'm hearing lots and lots of kudos. So thanks to both of you. Thank you again, Joe, for being the excellent webinar host that you've become. And I wish you all a great rest of the day. Let's bend that curve.
Great. Thank you, Ron. Thank you for all that you're doing at OCNI, and thank you for the chance to put a suit and tie on for a change.
You really look fantastic.
Okay.
And so does Ahab. You look good too, Ahab.
As long as I don't stand up.
Okay. Thanks, everyone.